Okay, let us talk about the relationship between law and justice. Okay, we are accustomed to the definition of law, and the basic or the classic definition of law is that law is a rule of conduct, just and obligatory, laid down by legitimate authority for common observance and benefit. This is according to Spanish jurist Francis Romano. Okay. The thing about the law is that laws, most of them are promulgated. When we say laws that are promulgated, we are referring to human positive laws, as distinguished from moral law or divine law. For example, human positive laws are laws enacted in the form of statute or promulgated in the form of decision. And whenever a statute is promulgated or enacted and the decision is promulgated, we may read the text of the statute and the text of the decision. And that's why we refer to law as a concrete term or a concrete concept. On the other hand, when we speak of justice, we are speaking about an abstract idea. Justice connotes giving each man his due. For example, under the contract, if A enters into contract with B, justice presumes that they have entered an agreement on equal footing. Commutative justice demands that A should comply with his part of the bargain or with his obligation in the contract, and that B should also comply with the obligation under the contract. In this case, we will see that justice requires that what is due A should be given and what is due B should be given. Justice is an abstract term. Why is it abstract? Because justice is not in the form of right. You cannot say justice. Although you may approximate or may sense that under a certain situation, justice is done. Okay? Justice is actually a moral concept. It cannot be promulgated or enacted into law. So, what should be the proper relationship between law and justice? Take note, while they may be interrelated, they cannot be considered as one and the same. They are interrelated, but they are not equal. Why is this so? Remember our basic description about the law as a concrete term, and our description about justice as an abstract concept, considering this different level of the attributes between law and justice, they can't be considered as one and the same. Okay? Law actually is a means towards an end. For example, to promote peace and order, to punish criminals, to enforce contracts, or to set the structure of government. And therefore, law cannot be considered as an end. Law is merely a tool to achieve something. On the other hand, since justice is never promulgated, okay, justice cannot be considered as a means. Justice is actually the end of certain human conduct. For example, we do things every day in order to serve others, in order to have a society which will take care of these and underprivileged members of society. Okay. We are doing this in order that justice may be approximated or justice may be seen in day-to-day living of our people, in our own interaction. And thereby, if we are going to look at this, law should be considered merely as a means towards an end. Remember the basic principle. Good laws are effective means towards the taking of justice. And bad laws cannot be used to attain justice. Bad laws may only attain justice. And therefore, in order that we may see the proper relationship between law and justice, we must have two laws. Our laws must be the ones that promote justice, the ones that promote equality between people, the ones that look at the least or at the disadvantaged people, the one which seems to be equitable and actually equitable in practice, so that justice as our goal might be seen and might be acquired or attained or might be approximated with the use of law. Remember this relationship between law and justice. Thank you. I'll see you again for another session.